everyone, and welcome to this Federalist Society virtual event. My name is Edith Harold, and I'm an Assistant Director of Practice Groups with the Federalist Society. Today, we're excited to be hosting this FedSec forum called Checks and Balances, Deregulation Based on Supreme Court Rulings. We'd like to welcome our excellent panelists today, John Lewis and Jonathan Wolfson, and we're very thankful to Craig E. Lean for moderating their conversation. Craig is a partner at K&L Gates and is a former OFCCP director. If you'd like to learn more about today's moderator or speakers, their full bios can be viewed on our website, fedsoc.org. Near the end of the program, we will turn to the audience for questions, so if you have a question, please enter it into the Q&A function at the bottom of your Zoom window, and we will do our best to answer as many as we can. Finally, I'll note that, as always, all expressions of opinion today are those of our guest speakers and not the Federalist Society. And with that, Craig, thanks so much for joining us today, and I'll hand things over to you.
Thank you, Edith. It's such a pleasure to be here. Thank you to the Federalist Society. Thank you to my esteemed co-panelists, Jonathan and John, both who are experts in the field of regulations generally and administrative law. So I'm excited to have them here. This is going to be a fascinating subject. I used to be a local government attorney, and our local government, I was the city attorney of Coral Gables. We had regulations. And as the city attorney, my job was to make sure those regulations were consistent with what was adopted by the city commission. And of course, sometimes they would be challenged or there'd be a court case. And I actually had the authority under our city code to adjust or to revise our regulations to be consistent with applicable law, with anything that was preemptive, with any superseding changes, to make sure that our regulations were consistent with law. So when the president on April 9th, 2025, issued a presidential memorandum called Directing the Repeal of Unlawful Regulations and listed 10 Supreme Court precedents, which we'll get into in a little bit, but 10 Supreme Court precedents, which truthfully have changed administrative law to a large extent and some other areas of law as well. When that was issued, and the idea was that, well, now let's look at our executive branch. Judicial branch has spoken. Let's look at our regulations and conform them to these Supreme Court decisions. I must admit, I saw a little bit of what I used to do in local government law in that, and I understood that. It made sense to me. At the same time, we have the Administrative Procedures Act, statute from Congress, so the three branches are all at work here. Congress has spoken on how regulations are revised or altered. And, typically that goes through a notice and comment process. Interestingly, in this memorandum, it indicated that, well, maybe in an appropriate circumstance, you wouldn't have to go through that. You could just do a direct change to the regulations. And of course, we've been seeing a lot of activity by the executive branch in the Trump administration. And we have, and I'll give you one other example. I talked about being Coral Gables City Attorney. I used to be OFCCP director in the first Trump administration. And Executive Order 14173, which ended affirmative action in federal contracting and repealed Executive Order 11246, which was the President Johnson executive order establishing affirmative action in contracting. Interestingly, in that executive order, it said all of those OFCCP regulations related to this affirmative action executive order that I've repealed or revoked, you don't have to follow those. We're going to give you 90 days where you can if you wish, but you don't have to do them going forward, which was a form of executive directive saying we're not going to be enforcing those provisions. And of course, in talking to my esteemed co-panelists, they indicated a number of other examples where presidents, Republican presidents and Democratic presidents, have done the same thing in different instances and under prosecutorial discretion. But I think this is going a little bit farther in the idea that maybe there will also be a repeal of those regulations, not just non-enforcement. So this is fascinating from a constitutional law perspective, from a separation of powers perspective, and perhaps most of all, hence the title to our program today, from a checks and balances perspective with the different branches interacting with each other. So I'm going to turn it over to my co-panelists, to Jonathan and John, to give their perspectives on this memorandum. But before I do, I just want to set the stage a little more by also just referencing the fact that this is not the only presidential action in the area of deregulation. There's other ones that are also involved here, and I want to just set the stage. So on January 31st, the president issued an executive order indicating that there were going to be 10 deregulations, 10 deregulatory actions to every one regulatory action. Now, you may remember this from the first President Trump administration, but there it was 2-1. So 2 deregulatory actions to every one regulation, 2 deregulations to every one regulation. I remember as an agency head, if I wanted to do anything that could even be considered regulatory, I had a very high hurdle because that also meant that there were going to have to be other provisions eliminated. Now it's 10-1, which makes me think that you were not going to see much in the way of regulation in this administration. It's going to be almost all deregulation. And this presidential memorandum is likely a big part of that. Second, there is the Department of Governmental Efficiency. There, on February 26th, there was presidential action implementing that and indicating that federal agencies, the Department of Governmental Efficiency, that the federal government as a whole should be looking for regulations to eliminate, and that every agency head needed to do that, and they needed to coordinate with DOJ, who would also be doing that. So this is a government-wide effort as well. And then third, there was a deregulatory RFI, a request for information, issued to the entire country or world, I guess, saying if you know of any regulations that don't support economy and efficiency, that may be illegal or adopted incorrectly, that may have more burden than benefit, that may be arbitrary and capricious, please let us know about them. And now this is also being done with HHS, with the Make America Healthy Again initiative. So there's another deregulatory initiative. And my understanding is that there were thousands of responses to the deregulatory RFI. Okay, so now so deregulation is the word of the day. The question is, to what extent can the executive branch do this itself unilaterally based on judicial branch precedents, in particular Supreme Court precedents, which of course are binding law? So I've spoken enough. Let me turn over to Jonathan and then John. Jonathan, what's your take on what I talked about, these different presidential actions, and in particular on the presidential action directing the repeal of unlawful regulations? And then John, please go after him.
Thanks, Craig. Good to be here and glad to share the stage with you, John. I think there's 2 big things that people should be paying attention to, and a lot of this is all still very much in motion. But I think your point, Craig, that this is part and parcel to a deregulatory agenda. So, Craig, when you and I were at the U.S. Department of Labor together, that in the first Trump administration, that was a significant point of emphasis in the administration, trying to figure out what are the cost savings from deregulation was an important part of work that we were doing every single day. And so that mattered. And I think that this doubling down or, 5Xing down on the deregulatory emphasis is a big thing. And so I think that this is part and parcel to that. And so it is going to be a major emphasis of this administration. I think that you're going to see a lot of activity to pull down regulation to try to identify whether or not there are regulations that didn't belong on the books in the first place, whether or not those regulations that are on the books need to be enforced. All of those are conversations that are going on. But I think something really important about this memo in particular, and this is the second point, is that there are a whole host of kind of directives that this directive is giving that may not all align with one another. The Supreme Court opinions that are cited stand for very different principles. Some of them are constitutional principles. Some of them are statutory interpretation principles. Some of them are interpretations of a very particular statute that deals with a very particular branch of the federal government. And so there's a question that each agency, I'm sure, has been wrestling with, which is how applicable are each of those opinions to them as a department, but then more specifically, are each of those opinions to the regulations that they have on their books? And so I think that that's a really important question that agencies are going to have to navigate. And if they ultimately determine that those opinions do apply to the regulations that they have on their books and that they are in violation of those constitutional principles, then the remedy that those agencies choose is going to matter for an Administrative Procedures Act direction, right? If the agencies just simply withdraw the regulation and say, hey, the Supreme Court told us we couldn't have this regulation, right? So when Fish and Wildlife withdraws a regulation because Loper explicitly says you can't have this restriction on requiring entities to pay for it, that regulation, clearly they have the authority to withdraw without going through notice and comment. But if the Department of Energy decides to withdraw a regulation in the Nuclear Regulatory Commission space, and their only basis is that under Loper we didn't have that authority, that may be a very different kind of conversation. One is very clear, the court almost wanted them to do it or even says you have to withdraw this. The other is interpolating from that opinion, which it's going to be. And so I think that some of this is a interesting wait and see, and then we're going to have to see how the courts approach the position that the agencies take in trying to withdraw these regulations.
Thanks, Jonathan. What are your thoughts, John?
Great. Thanks so much, Craig, for moderating today. And thanks so much for that hard to follow introduction, Jonathan. And thanks to the Federalist Society for hosting today's session. I wanted to sort of put the April Memorandum in the context of the administration's broader efforts to expedite the deregulatory process, some of which you alluded to in your opening as well, Craig. But I think, as everybody watching knows, President Trump has spent the last several months trying to rein in the administrative state by, slashing the federal workforce, eliminating entire agencies. Regardless of whether you think those developments are good or bad, they've depleted the federal government of a lot of the civil servants who would typically shepherd rules through the regulatory process. And I think the administration is dealing with that now. As both of you know, and anybody who's worked in the federal government before knows, the rulemaking process consumes a ton of time and resources for agencies by publishing proposed rules, considering potentially tens of thousands of comments, then writing a final rule. And now the administration, which I don't think was ever really a fan of the notice and comment process to begin with, is really going to struggle to find the personnel who are going to perform these functions. So the April Memorandum in that context is one of a series of, I think, increasingly creative mechanisms for circumventing notice and comment. My favorite is the same day as the April Memorandum, the president issued an executive order directing the Department of Energy to skip notice and comment and rescinding its definition of a showerhead. So that represents, I think, another approach to this shared problem. And look, I understand how they feel. I think every administration since the enactment of the APA in 1946 has experienced the regulatory process as a hindrance to its goals. But I think the memorandum suffers from some pretty significant deficiencies, some of which overlaps with the points that Jonathan made, and as my organization, Governing for Impact, laid out in an issue brief on our website. So, as we've mentioned, the memorandum directs agencies to examine whether their regulations conflict with 10 major Supreme Court decisions, and if so, to repeal them immediately based on the good cause exception to notice and comment. But the meanings and scopes of those decisions are contested. These are some big Supreme Court decisions that people are continuing to debate today, and it won't always be clear whether a rule is unlawful under these decisions. Even if a rule suffers from legal deficiencies, immediate repeal in full will not always be the right answer, as the Supreme Court emphasized in the Regents decision, which dealt with the first Trump administration's attempt to rescind the DACA program. An agency has to consider reasonable alternatives to repealing the program in full, like partially repealing it or phasing it out over time. I also think no case has really accepted the administration's interpretation of good cause, and the DC Circuit has cast a shadow on it. In a 1982 case, Consumer Energy Council of America, the DC Circuit rejected the argument that notice and comment requirements do not apply to, quote, defectively promulgated regulations. Among other things, because it would ignore the fact that whether the regulations are defective is a question worthy of notice and comment. And I think the two prongs of good cause that the administration is citing don't really provide them with much help. It cites the unnecessary prong of good cause, but that's really supposed to be for more minor routine changes where nobody really cares enough to comment about the rule. And it relies upon the contrary to public interest prong, but that involves situations where providing advance notice would undermine the purpose of the rule. So I think courts are going to look askance at this reading of the APA. But I think if the theory is ultimately upheld, it's going to set a bad precedent for administrations of both parties. Although notice and comment can be frustrating, it serves some really important purposes, like improving the quality of decision making and public participation. But I think if you get into this posture where administrations are repealing rules without notice and comment super quickly, I think it's going to lead to a lot more uncertainty. It's going to lead to a lot more flux in the regulatory space, where the regulatory regime is just changing over and over. So, I think I've said enough, but I think rather than trying to find one weird trick to expedite deregulation, I think the administration might be better served by just sort of digging in and doing the work and issuing rescission rules through the notice and comment process.
So, I'll tell you, when I was at Labor, and Jonathan, I worked with him, as he mentioned, and when I had an action I wanted to take, whether it was regulatory or sub-regulatory, it would often go through Jonathan. He would take a look at it. He had about 100 actions that he was looking at any time. So, and that's been true in Democratic and Republican regulatory agendas. There's always like 100 for every department. And I'm sure in this administration, there'll be many of those. And as mentioned, some of the losses in personnel may make that a challenge to do that. So I'm sure that where the administration feels like it can act directly based on a court precedent, I'm sure it will want to take that action. We've seen that when President Trump issues an executive order, they do follow up on it. They do seem to be implementing them and taking that as the position of the executive branch. So let me ask you. So there are 10 Supreme Court precedents. I won't go through each one, but for anyone who's listening today, it's the April 9th, 2025 Presidential Memoranda called Directing the Repeal of Unlawful Regulations. I'll just name some of the cases. These are big cases in administrative law. Loper Bright v. Raimondo, West Virginia v. EPA, SEC v. Jarchese. There's a number of other ones involving the EPA. Students for Fair Admissions v. Harvard, which is a huge case in the DEI affirmative action area, and the administration's been seeking to apply it broadly. Carson v. Macon. There's a number of cases here. Let me ask you about SEC v. Jarchese. That's an interesting one because that involves administrative law judges and whether some of these cases really need to be done before an Article III court or not. I would think with SEC v. Jarchese, for example, you'd probably still want notice and comment before you move from using ALJs to having cases brought in front of Article III courts, for example, because that would be a significant change to the way an agency or department enforces the law. And yet, having said that, if it's truly unlawful to use an ALJ in a particular proceeding, I mean, I know they're moving away from OFCCP, but it's a good example. OFCCP was essentially, even though it was an administrative proceeding, and they were enforcing anti-discrimination law, it was basically applying the Title VII standard. So you could make an argument that a case like that really maybe should be in front of a Article III court, not in front of an administrative law judge. Isn't there something there that maybe the departments do need to act right away so that they can maintain their ability to enforce the law, and that it wouldn't be right to bring a matter before an ALJ right now if the administration fairly thinks that it's unconstitutional? And wouldn't that mean that they should go forward and do a direct rule? I mean, isn't there something to this?
Happy to jump in, or Jonathan, if you want to take the first crack. I think Jarchese is kind of a tricky case because there are some real questions about the effects of Jarchese and how it bears on all these different administrative adjudicatory schemes. It was focused on a specific remedy that the SEC was seeking that seemed like a remedy that you get in common law, damages and fines related to that. I think it's not entirely clear how Jarchese will apply to every agency's administrative proceedings. And so I think this gets at the question earlier. If the rule we're talking about literally involves the SEC's administrative scheme, that's closer to Jarchese, and there's a stronger argument that the agency should just sweep that off the books immediately. But if we're dealing with a different agency, different remedy, different issue, it's not as clear whether the agency's administrative scheme can survive. And so the basis for providing notice and comment in those circumstances is, I think, a bit stronger because this is something that the public might want to weigh in on. It's complicated, though, because I'm not sure how many of these schemes are laid out via notice and comment in the first place. These may be agency procedural rules. They may be discretionary practices. So it's not really clear to me how much you need this memorandum to expedite that aspect of the process. So Jarchese, some of these bigger decisions like Loper Bright in West Virginia, these could affect every aspect of administrative decision making because they set sort of the rules of administrative law. But some of these more idiosyncratic, narrow decisions, I think it remains to be seen what effects they will have.
Jonathan, any thoughts?
Yeah, I think that the interesting thing about the Jargasi decision is in a lot of those cases, the agencies are the ones that have pushed to use the administrative law judges. And so I'm not sure that you would need to do any administrative law action. All you would just do is, you know, if you're at the U.S. Department of Labor, it's the solicitor, other departments, it's the general counsel. They could simply direct their staff that rather than filing the action against the party in front of an ALJ, that they will just take it directly to the court. Or you could say, hey, we're not going to require an exhaustion of administrative remedies. Like, we are going to have an internal policy that says going forward, we will not raise failure to, you know, exhaust administrative remedies as part of our pleadings when we're opposing a motion to, you know, bring this case into federal court. And so I think that in some ways, to John's point, this is a very narrow decision for purposes of what the other agencies can do. I think that the principles of Jargasi are significant, and they are principles that I do think probably do go across all party lines. I think most people who look at it from kind of a normal citizen view of the world think it is a little strange that the agency might be able to be in charge of writing the regulation, enforcing the regulation, and being the judge who decides. And yes, there's an appeal process and all that, but I think that to the average voter in the world, that does seem a little strange as a process. Now, so the lawyers who are watching, they're all like, well, but the number of cases that would be in the federal court, and there are reasons that the administrative system exists, and there's some things like, you know, Social Security appeals, which really are a very process-oriented thing. It doesn't require the same type of process that you might need in front of a federal judge. But in some ways, it's kind of why we have magistrates in federal court. It's the same sort of thing. We've created administrative law judges. But I do think that the agencies could very quickly, if they wanted to, just circumvent the ALJs. Now, that becomes an interesting question of federal employment law and what that does if they're no longer utilizing the ALJs, and whether or not those folks need to remain as part of the federal workforce. But that's a very different conversation than the one that this particular directive from the president is telling agencies to look at.
Okay, well then how about, so John mentioned Loper Bright and West Virginia v. EPA, major, I mean, basically materially changing administrative law. I mean, that's probably an understatement. So you have those two huge cases. The Chevron doctrine is gone. The major questions doctrine is here. You have Loper Bright. So what does that mean? So, you know, I've been thinking about this a lot. You know, a lot of EPA rules have huge economic significance, maybe not directly addressed by Congress, or even contemplated when these rules came into place. Certainly occupational safety. I know OSHA itself has been challenged in the past, long ago. So, you know, you have these rules coming up that are regulating huge parts of the economy. Does that mean that, do you think that it's the administration's perspective that these rules that were adopted 10 years ago, 15 years ago, before Loper Bright, before the major questions doctrine really came to be what it is now? Like, basically, I know that used to be, it would come up from time to time as a canon of construction, but now it seems to be a principle of at least administrative law, but maybe constitutional law. So you have these principles out there. Can the executive branch say, you know what, we're not enforcing? Well, let me ask you two parts. One, can they say we're not enforcing this wide array of environmental and occupational safety regulations because we believe it's unconstitutional under the major questions doctrine, and we're going to go forward and eliminate them with notice and comment? And then two, could they just do direct rules saying we believe that this violates the major questions doctrine, so we're eliminating these rules, and we'll go through a notice and comment to establish an alternative rule or something like that? What do you all think?
Yeah, so I think the first question of enforcement discretion, I think agencies have traditionally been given pretty broad latitude on enforcement discretion. There's limited federal resources, and there's not an ability of the citizenry to have standing to challenge a decision not to enforce particular laws. Now, there's a handful of places where citizens can challenge it, but generally that's a court of public opinion thing. If President Obama in office told the Homeland Security they were not going to enforce certain immigration rules and laws, and there were a lot of conservatives who made a significant political argument about that, but they really were never able to level a legal challenge that forced the administration to change that policy decision. Similarly, the first Trump administration made particular enforcement decisions about things they wanted to focus on and things that they were less concerned about focusing on. There were some DOJ memos even early in this current administration about things that they were going to prioritize and deprioritize. I think that is generally pretty broad discretion. The interesting question that I have on is particularly with Loper Bright is because Loper Bright is talking about a principle of interpreting law, there is an interesting potential path here for the administration. And if the administration wants to say that there is a vague statute and the best read that everyone agrees of that statute, it might be vague, but it's only vague because we've all decided we have this special rule about how we have to interpret things that aren't explicitly clear. But we know from how the law was passed that everybody knows the law is actually intended to do one thing. And then agencies have, because of Chevron deference, been able to say, well, but there is a small window here of how do you define safety at the Consumer Product Safety Commission, or how do you define contaminant at the Environmental Protection Agency? And because we're going to have different levels of safety or levels of contamination, the agency now has discretion. And everyone knows that there's no world in which Congress would have said there can be no coal-fired power plants when they passed the Clean Air Act, but we've now defined it in such a way that that happens. I think that that's a path where the federal agencies right now could do direct rules and simply say, the law, the only reason this regulation was able to happen was because the courts defer to the agency's interpretation of statutes, but it's not the best interpretation, and therefore we're going to withdraw it. I think that if they stop there, they're going to have a much easier time. If, on the other hand, they then turn around and say, this is not the best interpretation, but this alternative one that is a policy that we prefer is, and then they simply say, we think that this is also policy beneficial to go down this alternative path, I think that's where the courts are going to give them a lot more scrutiny, because it is a lot harder for the comments that will come in if they cabin their discussion to simply, it was not lawful for us to do this rule in the first place, to deal with the implications of those regulations. And so then it really is about whether the agency had that authority. And so that's the real question I have, and what I'm going to be watching for as the agencies put out proposed regulations or direct final rules, however they go about doing it, is are they doing it simply saying this was not lawful and therefore we withdraw it, or are they putting some alternative thing in place?
So John, what do you think about that? First, on the enforcement piece, do you think there's a broad discretion not to enforce, including based on these Supreme Court cases, and then maybe a future administration would take a different tact and start enforcing again? So do you agree with that? And then second, what about the idea, at least in certain areas, that a direct final rule would be allowed, or are you skeptical of that?
Yeah, I think those are both great questions. And I think you're right to put together the question of rescinding rules without notice and comment and the issue of non-enforcement, because I think the administration has been pretty candid that they see these as two prongs of a broader strategy. There was a New York Times story back in April where the administration admitted that they would use this memorandum to try to rescind rules quickly, but when they can't rescind a rule immediately, then they'll engage in enforcement discretion to not enforce it in the interim. It's true to anybody who's taken administrative law that enforcement discretion is broad. That's what Heckler v. Cheney from the 80s says, that an agency's decision not to enforce a statute or a regulation against a particular policy is presumptively immune from judicial review. But I think the administration is maybe not going to be able to extract as much from Heckler v. Cheney as they want. I think Heckler itself mentions that there could be an exception if an agency completely abdicates its statutory or regulatory responsibilities, if it just decides across the board that we're not going to enforce a regulation because we don't like it. And the DC Circuit has picked up on that in the subsequent decades, distinguishing Heckler as a case of think the word is a single shot enforcement decision, where they decide not to enforce against one particular party versus setting a broad categorical policy of non-enforcement. So I think there is a little wiggle room in Heckler if the administration decides to just stop enforcing all of these rules in the interim. On the question of whether you could use the major questions doctrine to rescind some of these rules immediately, I think courts are going to be skeptical of that. I think an administration coming in and saying that we don't like this rule, because we think it involved a politically salient topic like abortion or LGBTQ rights or something like that, or saying that we think a rule is super costly and so we think it's economically significant. I think courts are going to be skeptical of sort of that broad claim because that could be invoked to rescind rules in a lot of different contexts, far afield from what West Virginia v. EPA and these other cases actually involved. And I think it's going to put the administration in a tricky position. It remains to be seen how much affirmative regulation the administration wants to engage in. But if they say that they're rescinding a rule because it dealt with, a politically salient topic like abortion, any regulation that they do on that subject, well, litigants are going to come in and challenge it. And they're going to cite the same things that the administration said before as evidence that it is also a major question. And I think future administrations might pick up on that too. They might look back at some of the things that the Trump administration did and said, well, these are all major questions. We're going to rescind these rules immediately too. So I think the important point is that to the extent these mechanisms are upheld, they go both ways. And I think that goes back to the point I said before about how it just leads to more sort of flux in the regulatory state, quick changes of regulations from one administration to the other that leaves everybody sort of, I don't know, constantly guessing about like what the rules are going to be moving forward.
So at this juncture, why don't I read one of the questions? Let's bring in one of the questions from the audience. So there seems to be tension between cases like 7 County Infrastructure and FEC v. Prometheus, emphasizing deference under arbitrary and capricious review, and DHS v. Regents and Ohio v. EPA, emphasizing agencies allegedly failing to address certain questions. The first line of cases might allow deregulation after a shorter and more succinct, but still adequate notice and comment process. The latter could be used to enjoin all final rules issued in the deregulatory agenda. Which line of cases reflects the trend that SCOTUS and that the Supreme Court and appeals courts will use towards deregulatory rules issued after notice and comment? So, and a lot's in that question. Why don't each of you address any part of that you'd like? Jonathan, why don't you go first?
Sure. So I think that the real question, and part of this goes back to my earlier point, is the real question is how does a department go about issuing a deregulatory rule by notice and comment? If what they're doing is they're saying we're going from rule A to nothing, I think that at that point the question is going to be very much an arbitrary and capricious standard. Did they say we didn't have legal authority to do this and now we do? For example, if the First Amendment didn't exist before a certain point in time, and then the First Amendment gets added, but there had been a Federal Communications Commission regulation that said you can't print the letter S in a newspaper for whatever stupid reason, right? But then the First Amendment hits. Obviously, the day after the First Amendment becomes constitutional law, that regulation ceases to exist. So if the FCC pulls that down, they don't need comment on it. And so at that point, if they go through the notice and comment process just out of an abundance of caution, the courts are not going to say, well, you didn't review this comment where this guy said, hey, maybe the framers of this new constitutional amendment didn't actually think about your regulation. No, they're going to just say, look, you're doing it and you're reviewing comments out of an abundance of caution. If on the flip side, you're going from regulation A to regulation B, where you're actually just changing the regulation from one, to John's point, that is your political opponent's preferred interpretation and policy to your preferred interpretation and policy, then I think that the courts are going to say, if you go through notice and comment, which you probably are required to do if you're actually just changing from one thing to another, that all those comments had better be reviewed carefully, that you're going to have to explain why you went from A to B. And if you fail to do that, under the Administrative Procedures Act, you're still going to be held to that standard. So I think that it's less about a lever in the direction of whether it's regulatory or deregulatory. I think it's much more a question of, are you going from something to something or something to nothing? And in this latter category, you're going to have a lot more discretion to just get rid of things without explaining what you're doing, in my opinion, because the courts are going to say, as long as you're pointing to a legal basis for doing that, that you don't have to respond to all these comments about why policy-wise that may not be a good idea.
John, what's your take on it?
Yeah, I agree with a lot of that. I think it's going to be harder for the administration to go from something to something, as Jonathan said. If you're replacing with an affirmative new regulatory regime, I think courts are going to look at that more closely. But I think arbitrary and capricious review is still on the table if the agency is going from something to nothing. The question from the audience picked up on this tension that has been inherent in arbitrary and capricious review, I think, since the beginning. If you go back to its origins in State Farm, the court says both that arbitrary and capricious review is deferential, and it says that courts need to, take a look at whether the agency really did its job effectively, which is the origin of hard look review as a term for arbitrary and capricious review. And in recent years, the court has said both things too. It said in Loper that it wasn't disturbing the deferential standard of arbitrary and capricious review. In the recent cases, specifically the NEPA one, it said courts need to be deferential to these assessments by agencies. But then you also have these cases coining new forms of arbitrary and capricious review that are a lot less deferential, like the Wages versus and White Lion case, where it coined the change in position doctrine for the first time, like Regents, where it looks at whether the agency considered reliance interests, like the Department of Commerce citizenship question case, where it took a look at whether the agency's reasoning is pretextual. I think arbitrary and capricious review has still some teeth to it, and I think courts are going to apply it to the decisions that the agency is making. And I would look at Regents in particular. I think that case is really on point to some of these rescissions for unlawfulness, where the first Trump administration tried to rescind the DACA program based on concerns about its legality, that prosecutorial discretion didn't justify what DACA was trying to do. And even there, the court said, look, even when you're rescinding a program because you think it's illegal, you have to consider these alternatives. You have to consider these reliance interests because people have relied on this program for many years. You have to consider whether you can just repeal the unlawful parts of the program and leave other parts of the program intact. You have to consider whether you can phase the program out over time to sort of protect those reliance interests. So I think these are all questions that courts are going to ask if we start getting into rescinding rules on this ground.
Okay, so let's use like a hypothetical. So Students for Fair Admissions is a good example. So it's a case that was in the higher education area, saying that there could not be preferences or a plus factor used for race in higher education admissions. The Trump administration has been very clear that it views that precedent expansively to apply in other areas and to apply to any sort of preferences. There's a lot of regulation. I know I practice in this area, so there's a lot of regulations on the books at almost every department that has any sort of program that interacts with the public, either under Title VI or to some extent under Title VII. But that and apprenticeship, lots of different programs which have regulations where it does look at racial composition, gender composition of programs, where you have disadvantaged business set-asides, where you have supplier diversity programs, which is the word that's used in the private sector, but you have things like that in the federal regulations. You have affirmative action regulations in some areas too, Department of Transportation. How do you approach that? So on the one hand, you do have this principle, and it'll be interesting to see what the Supreme Court does with that ultimately when these issues come up to them. How would you approach that if you were a federal agency? And let's assume you didn't have a position on whether these were good or bad or helpful or not, but you do have a directive from the president that you need to apply these expansively, this principle, that's the president's position as well through executive order. How would you approach regulations like EOC regulations with the voluntary affirmative action plan to transportation regulations regarding making sure that you're including disadvantaged businesses to equity analyses when you're placing a new building or something like that? How would you approach that? Like, which regulations would you not enforce? And I know I'm in a general sense. Which regulations might you just repeal? Which regulations do you think really do deserve a full notice and comment and a discussion? How would you approach that? Jonathan, why don't you go first?
Yeah, so I think a big part of it will depend on the operative statute under which you're working, right? And I think that is going to have to play a role. So if you are implementing an affirmative action style program and you are in, say, the K-12 space or in the postgraduate space, so some space that is clearly regulated by the U.S. Department of Education, it's really hard to tell a story that the Supreme Court opinion in Students for Fair Admission doesn't apply across the education space. And so if you are in those departments, it's going to be pretty simple for you to extrapolate that to other affirmative action programs inside of the inside of Title VII or inside of Title 6 and 4 and, Title IX, like the spaces that are in the education space makes a lot of sense to do. If you are in the Department of Labor and you're in the Employee Training Administration, which does, used to actually be merged with the Department of Education back before the Department of Education existed, right? Like some of those departments that do direct employee training, there's some, some work in childcare at HHS, where those things are part and parcel historically to the education system, might be, again, a relatively simple thing. On the flip side, if you're at the, at MSHA, which is the, the Mine Safety Health Administration, and you have an affirmative action regulation, or if you are at Department of Homeland Security, or you are at the Environmental Protection Agency, and we're not talking about education, we're talking about some other sort of program, right? How grants are being issued or things of that nature. You're going to have more work to do to explain how Students for Fair Admission applies to your situation. Again, it doesn't mean that you can't use it as a basis for it. But I would imagine that both the career and the political appointee lawyers in agencies, the further you get away from kind of the concentric circles around the department that is specific to that opinion, are going to say, hey, it may make more sense for us to go through full notice and comment before we do this. Whereas I would imagine that the folks in the legal shop at Department of Education are, while they may have political or the policy disagreements about whether or not that is good policy to change those things, I think that it will be less likely that they can make an argument that it's not legal for the department to apply Students for Fair Admission to pretty much everything going on inside the U.S. Department of Education. So that would be kind of what I would do is I'd look at, are you related to it? What is the statute? If you have a statute that is expressly requiring you to do an affirmative action program, but it looks different than the kind of regulatory structure that allowed the affirmative action programs under Students for Fair Admission, that looks very different as well, because now you have to explain why Congress may not have meant it, or that the underlying statute that Congress passed is itself unconstitutional. And that becomes a much harder hill to overcome if you're inside of the agency trying to get rid of that regulation.
John?
I think that's the right way to think about it. I think this sort of concentric circles approach, where the further you get away from the Supreme Court decision, the agency has a higher burden to justify its decision and maybe more of a burden to take notice and comment. I think that's right. I mean, look, Supreme Court decisions cast a big shadow, right? They don't only stand for the specific thing that they addressed, but they also stand for a set of principles that has application in other contexts. But it may not be entirely straightforward how the Harvard decision applies to, racial discrimination in other contexts like employment. It may not be clear how it applies to programs like diversity, equity, and inclusion programs, which I think the administration has tried to take a hatchet to as well. The further you get away from the specific thing that the Harvard decision said, I think the more the agency is going to have to do. And again, to make the point that these things just aren't clear cut, I think of an example on the other side, which is the Supreme Court's decision in Bostock, which applied Title VII to say that it prohibits discrimination on the basis of sexual orientation and gender identity. The Biden administration went through a rulemaking for years applying that same interpretation to the context of Title IX. And the operative provision of that rule just said, SOGI discrimination is prohibited by Title IX's prohibition on sex discrimination. And courts were very skeptical of that. Courts said, Title IX is different from Title VII. The language is different. The considerations are different. Whether that's right or wrong, I think the courts have suggested that they're going to take a really close look at whether the Supreme Court decision really applies to the context that you're trying to apply it to, whether the same considerations are operative. And so I think that provides some caution for this administration as well. I think this administration will have to think carefully about how much mileage it can get out of these Supreme Court decisions.
Yeah, and I'll just add, because John brings up Bostock, and I think that's a really valuable example, because Bostock was a statutory interpretation case, and so is Loper, right? And I think that so some of these cases are written by the Supreme Court in a constitutional frame of it is unconstitutional to do this thing, whereas other ones are written as it is not the correct read of this statute to read it in this way. And if you are an agency, kind of going back to my earlier example of pretend a world where there's no First Amendment and it gets created, if the Supreme Court has said that the Constitution now means this thing and a regulation violates that, very easy. And I think that the shadow that casts, to use John's language, the shadow that casts is going to be much broader Whereas if the Supreme Court simply says, we interpret this paragraph in the Occupational Safety and Health Act to mean this, that doesn't mean the Consumer Product Safety Commission necessarily has to interpret it the same way, because even if the words are identical, the Supreme Court may say, given the context, how these laws were passed, what the purpose of the law is, they may interpret it in different ways.
You know, Loper-Bright's an interesting one, what you both just mentioned, because you're right. So it's interpreting the Administrative Procedure Act. It's interpreting, essentially that a judge assessing a regulation does not have to defer to the executive branch. The judge issues an independent judgment. It doesn't say that it couldn't be set up that way. So presumably, at least they would have to look at it again if the APA was amended to require deference to the agency. Then it might become a constitutional issue, depending on how they rule. But it doesn't. So you're absolutely right. So let me ask you about Loper-Bright's an interesting one. It's the first one listed. Loper-Bright, in the decision, the court indicated that they weren't throwing out all prior regulations that had been approved pursuant to Chevron, that those could be looked at on an individual basis, but it was not a per se rule. And I think in part that was to preserve the reliance interest on those, and the fact that there were this has been the law for many, many years, since the Chevron case. But, and we all learned about that in law school, and that's how a lot of these regulations have been written and upheld. So it was in part to preserve the status quo to some extent and not cause disruption. Having said that, so let's talk about Loper-Bright specifically. Are there any types of regulations where you think Loper-Bright would call for their immediate repeal without notice and comment? Or does Loper-Bright itself, when you're going to be looking at whether this was approved by Chevron, because Loper-Bright indicates it's not automatic, at least with Loper-Bright, if that's the basis for repeal, does it almost require notice and comment? What are your thoughts?
I think Loper-Bright is interesting because statutory interpretation is in some sense in the eye of the beholder. I think people will look at regulations from the Biden administration and see a lot of inconsistencies with statutes and be interested in deploying this theory to rescind those. Somebody else might look at the Trump administration's first term and say, there are all these regulations that we think conflict with the statute or aren't the best reading of the statute. I think using Loper-Bright in this way is just so potentially open-ended and so two-sided that administrations of either party can go back and look at any regulations that they think are inconsistent with the statute and seek to overturn those. I think there's a lot of ambiguity about that critical portion of Loper-Bright that tries to preserve statutory stare decisis that says, decisions we've made on Chevron grounds in the past are not necessarily set aside. Our ruling that the agency action that was upheld is still lawful. What does that mean? If the agency makes a small change to the regulation, is that still covered by statutory stare decisis? If it is regulating under the same provision or a similar kind of action, is that protected as well? I think there are still a lot of these questions about how Loper-Bright applies to retrospective review of regulations that, coupled with the Supreme Court's decision the same term in Corner Post, really, potentially opens a lot of these questions up. I think to the extent they're trying to rescind regulations that have been on the books for decades, I think it's going to be a lot harder. I think the Supreme Court and the lower courts are going to want the administration to take a closer look at how these regulations have developed, who's relied upon them in the interim. I think just saying that, we don't think this is the best reading of the statute, and so we're going to rescind it immediately, I think that's going to be a tougher sell.
Yeah, is anybody who's watching this who's seen me speak on Loper at FedSoc event in the last year and a half will know I've told many people I think that we won't actually know what the contours of Loper-Bright are until we finish a complete Republican administration and a complete Democrat administration. I think we just so much of this is going to be regulation specific, and we're going to need to see how the various appellate courts interpret it, what cases make it through cert review and get to the high court, and how all those lines get drawn, because until we see kind of regulations that both whatever team you're on likes and dislikes make it through the process, it's going to be really hard to know what those lines are. That said, I do think that Loper-Bright offers an opportunity for agencies to look at kind of what was the basis. So, Craig, you and I were at the U.S. Department of Labor, and one of the interesting regulations that came out, and it's gone back and forth, was an independent contractor regulation, right? That when we were at the U.S. Department of Labor, we issued a regulation and we interpreted it one way, and then the subsequent administration came out, and the arguments used by the Biden administration in their interpretation of that statute were, in many cases, this is how we have done internal interpretive guidance, and that was a basis for why the regulation ought to be written in a particular way. In a circumstance like that, that may be a stronger justification for the current Trump administration to withdraw that regulation and say, look, they are not basing this on the text of the statute. What they are basing this on is some enforcement discretion and internal guidance that they have used in the past. That is clearly the agency's thoughts. It's not what the statute said. And so now we, the US Department of Labor, can withdraw that. That doesn't mean that they can then put the regulation that we worked on when I was at the Labor Department back on. That doesn't automatically put that back on the books. But if they want to withdraw it for that reason, those are the sorts of things that I would imagine that there are a lot of lawyers looking and spending a lot of late nights looking through those explanations for. But I do think that the attempt to use Loper as kind of a magic wand that can wipe away large swaths of the administrative rules is going to be hard. I think the reality is that Loper Bright is, for the current Trump administration, mostly going to be a sword against them instead of a sword that they're going to be able to use to deregulate. I think that people who believe in less administrative state and a less robust administrative state will long-term be happy. But during the Trump administration and the era of Doge and all those things, it will more likely than not be used to trip up those efforts. Again, Jonathan Wolfson still thinks that Loper Bright is a good decision, even if the short run outcomes of that end up being not to my personal policy likings. But I think that you're going to see probably a lot of people who were upset about the Loper Bright opinion because of their political proclivities being very comfortable with its use for the next 4 years, and a lot of people who are excited about it being very frustrated with it for the next 4 years. And then we'll see, depending on who is president in 2029, then those sides may very quickly flip back and everyone will be back in the spots they were the day Loper came out.
Well, it's interesting. I thought the focus on Loper Bright was very interesting because, the president's also issued an executive order, which we haven't talked about yet, which says that all legal interpretations of the executive branch are made by the president and the attorney general, and that takes precedence over agency interpretations, including by independent agencies. How does that interact with Loper Bright? Not to get off topic too much, but that wasn't mentioned here, but how the courts haven't addressed that yet? The idea that the president may say, look, this is how I interpret these Supreme Court decisions for the executive branch. Anything inconsistent with it must stop outside of the APA. Do you have any thoughts about that? The interaction of that executive order with Loper Bright?
So I think that the reality is administrations have policy processes, include both for the pure policy things, but also for legal questions. And the reality is DOJ and White House counsel's office have always been intimately involved in those. When I was in the Bush administration, there were meetings that we would have on issues that didn't seem like they were purely legal issues, on healthcare policy or on energy policy. And the White House counsel's office and Department of Energy lawyers would be in the room, but also folks from DOJ would be there. When we were in the Trump administration, Craig, we would be in those sorts of meetings. I have enough friends in administrations in between that to know that that was true in the Obama and in Biden administrations. I think that the reality is that's probably more of a saying what everybody knows to be true, who plays on the inside, but it might not be what we all learned in our civics class, because the understanding would be, hey, each of these agencies have lawyers who are the experts in those fields. But at the end of the day, if the Attorney General's office calls, Craig, when you and I were there, if the Attorney General had called the Solicitor of Labor and said the consensus opinion of the Department of Justice is that this is how to interpret this statute, that's going to carry a heck of a lot of weight in that meeting. It doesn't mean that that is what the law means, and the courts are not bound by it. But I do think in the policy-making function, to have that kind of clear standard is not surprising. It's probably just one that makes it very clear what the president wants the chain of command to look like in his administration.
John, do you have any thoughts on that?
I think it remains to be seen what the effect of the executive order is going to be. I mean, I don't think that President Trump himself is sitting down and, reading the statutes and reading the cases and coming up with these legal interpretations for, every question the executive branch has to come across. And there have always been these like coordinating and centralizing mechanisms within the executive branch, whether that's OLC at DOJ for legal interpretations or OIRA and OMB, which is trying to coordinate the regulatory process across agencies. I think perhaps all this means is that the White House related components of that process will have a heavier hand. Maybe OIRA or the White House counsel's office will have more to say about the interpretations of these statutes. But I think at the end of the day, courts are going to look at these legal interpretations and assess them on their own merits. I think to the extent it looks like this process is being driven more by the White House rather than agency experts, that may play like a behind the scenes role in how courts are assessing interpretations. But I don't think in the wake of Loper Bright, it plays any real significant decisional role.
Okay, so let me ask one more question and then we'll each make a final statement. So one more question from the audience. Given the administration has reduced the federal workforce necessary to do the NPRM process, should the administration instead use interpretive rules that the APA exempts from the notice and comment process? Jonathan, why don't you go first and then John?
So, these are the sorts of decisions that when I was leading the policy office of the Labor Department, we would have these kinds of discussions all the time. And there are pros and cons to interpretive decisions and interpretive rule. The pro is that, yes, you don't have to go through the notice and comment process. And so you can issue a regulation really fast. The con is that a mere change of the website by the next people who walk in the building eliminates your regulation or your rule. It's not clear that you can withdraw notice and comment issued regulations via interpretive rules. Like that's a legal question that's not yet ever been like directly addressed by the courts. I'm sure that there's some interesting legal scholarship on that question. But I do think that that's a challenge. So part of it is how long-term impactful does the administration want to be? And if the goal is simply for the next 3.5 years to not have these administrative burdens in place against various entities that are kind of tamping down the economy, then yeah, interpretive rules may be a really helpful thing. Just like they could announce tomorrow, Secretary Zeldin could come out and announce, hey, we're not going to enforce any EPA laws. Like that's just, we're going to completely stop. And people would then do whatever they would do. Obviously, there are state statutes and other considerations. There's still common law, all those things, but they could do that. But the day a new EPA administrator walks in the door, if it is someone who disagrees with that opinion, that immediately changes. Whereas if Administrator Zeldin gets on the loudspeaker of the Federal Register and says, we're going to change this via notice and comment, and they go through the process and it goes through the courts, and now there's a handful of current EPA regs that no longer exist. Now the next administrator can't come in and say, we're using enforcement discretion or an interpretive rule to start enforcing those things. They'll have to go through the process to get it all back on the books. And so to me, this is a question of longevity versus expediency. And I think that those are the sorts of questions that every administration has to wrestle with. I would imagine that as you get closer to the end of the Trump administration, depending on what they feel like the political winds are, there may be an interest in churning out a large number of interpretive rules to at least tell their constituents that they have, met their need. But if they think that, the vice president or someone else who they think is aligned with them is likely to walk into office next, they may want to set things up to have those be more long-term opportunities to take root.
Thank you, Jonathan. John?
Yeah, that makes a lot of sense to me. I think there are a lot of unresolved legal questions about the use of interpretive rules, as Jonathan alluded to. There's a Supreme Court decision called Perez v. Mortgage Bankers Association, which I've always taken to stand for a sort of process in, process out rule. You have to use whatever process you use to promulgate something to rescind it. But there are questions of if it's an interpretive rule that you didn't have to use notice and comment to promulgate in the first place, do you have to use notice and comment to rescind it? I think there's also a lot of case law about drawing the distinction between interpretive rules and legislative rules. What the administration characterizes as an interpretive rule, the courts may have a different view and may see it as more of a legislative rule. So I think those are some of the challenges in this robust use of interpretive rules possibility. I also just think it would be a little ironic for the administration to turn to interpretive rules, because this administration, during the first term and now during the second, has been very skeptical of so-called guidance documents as a way of, letting agencies regulate private behavior through, informal, quick processes, and has, encouraged agencies to rescind guidance documents as appropriate. So if it turned now to issuing a slew of interpretive rules, I think that might conflict with some of the positions that it's taken before. In addition to the issues about interpretive rules being less sticky, being a little less forceful, that Jonathan was mentioning.
It's a really good point. And I do remember that from my time at the Department of Labor. So I want to give each of you a chance to give a final thought. I also want to thank you both. You're two of the most knowledgeable people in this area in the country. When we were putting this together, I'm so happy that we got both of you to be able to do this. So thank you. And it's been a fascinating discussion today. Jonathan, why don't you go? Give me a final thought, John, and then I'll close it up. Jonathan?
Yeah, well, thanks again, Craig and John and the Federalist Society for hosting today. I think one of the most interesting things to me about this conversation is that we've mentioned Congress pretty much not at all. And the reality is Congress could, if they wanted to, address a large portion of these questions. If Congress wanted to delegate clear authority to the agencies to issue regulations, then it becomes very clear to the courts that the agencies have that authority. If on the flip side, they wanted to write clear statutes that explicitly remove the delegation of authority from the agencies to issue rulemaking, to clarify or to potentially change the meaning of their statutes. And so I think that one of the really interesting things about administrative law is that we kind of just take for granted that Congress is not going to do its job, and that Congress is going to write vague statutes, and that agencies are going to be left trying to figure out what to do. And then each president and administration are going to walk in and have to figure it out. And so I'm very curious to see how this specific directive from the president is implemented. But I do think that a lot of this is, while important, is the sort of thing that maybe some of the effort should be made to, rather than just withdraw a regulation, to go to Congress and say, you need to codify the withdrawal of this or codify the regulation that is in place, because then it makes it very clear. And talk about sticky. If you can get Congress to codify a regulation that is currently on the books, it is very unlikely that it's going away. And the reality is the next administration can't change it based on a rule. They're going to have to go through the legislative process. So I think the legislative part of this is going to matter. And then I'm very curious to see how aggressive the agencies are in trying to use these decisions to withdraw regulations, and whether or not they use them to withdraw whole regulations or parts of them, or if they're using it to try to replace it with something else. And I think those are the big questions that we'll all be watching in the next 6 months to a year as the administration continues to get its sea legs.
Thank you, Jonathan. John?
Yeah, well, first of all, thanks so much to you, Craig, for moderating, and to Jonathan for the great discussion, and to the audience for tuning in, and for FedSoc hosting this great panel. What this discussion has underscored for me is that everything in administrative law goes both ways. We all flip positions every 4 years, depending on who the administration is, in terms of our views on the APA, on nationwide injunctions. There are principles operating in the background, but I think everybody who does this work knows that, one administration's tricks could just as easily be deployed by a future administration. And I really think that the Trump administration should take that seriously. I think it should think about the precedent it might be setting with some of these devices to get around notice and comment that future administrations might be able to use as well. But I also think these are a response to how difficult the APA can make regulations sometimes. The APA has some very detailed and elaborate and rigorous requirements that agencies have to jump through. And, much has been said, on the left about the questions over whether we should have such rigid procedures for agencies doing their jobs. And I think it may be a time in the future to think about whether these statutes, we talked about going back to Congress. Maybe Congress should start to rethink some of these basic procedures and ideas. But for now, I think, the APA says what it says, and I think there are a lot of good reasons why the APA imposes such rigid requirements on agencies, ranging from improving decision-making to public participation. So, I guess in closing, I would just urge the administration to adhere to those requirements rather than trying to circumvent them.
Well, let me tell you, it's been a tremendous discussion today. It's really a fascinating time to be in administrative law, and I know you both are. I am too. and everyone that's on here. I want to thank also, in addition to the Federalist Society, our administrative and regulatory law section, which I'm on our executive committee. I want to thank them for sponsoring too. There's more to come. We're going to see how this all develops. But when you were in law school, a lot of people didn't take administrative law. Well, you better take it now because that's the cutting edge, and that's where everything's happening. So thank you, and have a wonderful day. Edith, back to you.
Yes, on behalf of the Federalist Society, thank you so much to John and Jonathan for speaking and Craig for moderating. We're very grateful for your time and expertise today. And thank you also to our audience for joining us. We really appreciate your participation. You can stay up to date with other announcements and upcoming webinars on our website, fedsoc.org, or on all major social media platforms. Thank you once more for tuning in, and we are adjourned.